So here at Pondering Politics, I said this year that we would be having interesting conversations with interesting people, and I bagged the white whale of interesting people, Senator Sheldon Whitehouse, the Democratic senator of Rhode Island, author of The Scheme, How the Right Wing Used Dark Money to Capture the Supreme Court, and I think a crusader for judicial reform. Did I get that right, Senator?
Pretty close, yeah.
Some big news happened yesterday. You may have heard about it. Vice President Harris officially named her running mate, Governor Tim Walz of Minnesota. Could I get you to jump in on that, weigh in? What do you think of her selection?
I think that anybody who's watching or listening to this, if you haven't gone and looked up Vice President Harris's intro speech of Governor Walz, and then watched or listened to Governor Walz's speech, watch it because his face is worth it. Those two things are really, really worth seeing it. And they will completely settle the question of whether this was a good choice or a bad choice or a maybe choice. Just the energy, the enthusiasm, the confidence, as Walz said, the joy that emanates from the two of them puts us, way into happy warrior mode, which I think is exactly the right place we need to be to beat the stuffing out of Trump and Vance and make sure they never occupy the Oval Office.
Senator, I've got two conceptions of two threats to democracy. And if I get anything wrong or you disagree, you feel free to jump in. But to me, the immediate threat politically is Donald Trump and MAGA. There's no question about that. But the looming threat, the threat behind them, and it's kind of almost this feedback loop, is this unaccountable right-wing Supreme Court. These are two threats that I think the American people have to make accountable to the American people. Do you disagree with that? Is that a fair conception, would you say?
I think it's a pretty fair conception. I would add that you can't understand the problems of this very peculiar court without understanding the right-wing billionaires who created it, who cosset the friendly justices with lifestyles of the rich and famous, and who telegraph to them what they want them to decide through these little flotillas of front group amici curiae that they send in. So I don't see this court as an independent actor. I see it as a tool or a weapon of a bunch of creepy billionaires who've spent a lot of money and built a lot of infrastructure to make it happen. Leonard Leo is their sort of bizarre little operative. But I think you've got to look at the whole thing. But I agree with you. There are two very distinct threats to democracy, and we have to address both of them. If you were comparing it to an ER patient, Trump and MAGA would be the stab wound that the doctors have to look at immediately and try to cure and protect against. But there's also a cancer, and that cancer also needs to be treated. And that's this creeping infrastructure of billionaire-funded right-wing mischief that does a lot of different things. It's not just the court, but perhaps their primary thing is to capture and control the United States Supreme Court and have it do their bidding. And unfortunately, they've done a bang-up job of that.
My understanding, you hear this thing in social studies classrooms all across America, if you're lucky to hear it, which is that we have three co-equal branches: the legislative, the executive, and the judiciary. Now, when I went to college and I got my political science degree and I dove deeper into the documents of the founding fathers, what I found is actually we don't have three co-equal branches. We have three separate and important branches, but the word co-equal is never actually used in the Constitution. The founders clearly intended for the judiciary to be the weakest of the three branches, to be less powerful than Congress, and quite frankly, less powerful than the president. And yet, sir, it seems to me that what we have here is a complete inverse. It seems to me that the Supreme Court is your boss de facto. They can strike down congressional federal statutes. They can strike down presidential executive orders. They can tell you what to do, but they have taken it upon themselves to say you can't tell them what to do. What have I gotten wrong here? It seems like they have a conception where they get to be these 9 unelected philosopher kings issuing orders to the president and to Congress.
Well, I think you're right. I think the conversation of the founding fathers about the executive branch of government primarily had to do with balancing accountability and the ability to act freely, boldly, and rapidly when needed. And that was a conversation that played out through the founding era. But clearly, it had a baseline conception that the executive should be a powerful agency within certain restraints, but it was natural and important that it had power. Congress came even first. Article 1, that's us. And there were some concerns about, the minority being overruled by the majority, and how do you balance the occasional, immediate panics that flow through legislatures. So they did bicameralism, and they gave the governor a veto. But the fundamental premise of all of that is that the power of the government would be in the people's elected representatives in the government. And then when you get to Article 3, the third article about the judiciary, all of the fear is about them having power. They should not have power. They are not elected. They're not supposed to have power. The idea is to constrain them as much as possible. So it's got to be a real case or controversy before they can consider it. They don't get to offer advisory opinions. They're supposed to be bound by precedent. They don't get to go gallivanting off into policy disputes. But this group of far right-wing operatives, backed up by their creepy billionaires, has turned that on its head. And in every really offensive decision that they have made, which are far too many, you see a piece of it being a grab for power where they really don't belong. And sometimes it's the way they frame the question so that they butt into something where they shouldn't be there. Sometimes it's taking cases that aren't even real cases, Like if you're a court and you're real judges and you see a case come in where the plaintiff went to the original trial court and said, please, I want to lose as quickly as possible. And all of the lawyers around are politically active parts of a front group. And then they jump up to the circuit court and say, hey, please, we want to lose as quickly as possible. They're hopping to the Supreme Court to try to get to what they think is a politically attuned body that will give them what they want. A real court would take a look at that and say, we might just want to wait for another day for that issue. So this doesn't look so much like it's been framed up for us by political actors. But, apart from the case or controversy rules, this is kind of a fake case or controversy. Let's just steer clear. Instead, they've supported an entire industry of that. So they're very, very culpable in trying to ignore the warnings of the founding fathers about a court seizing too much power. That's what they're into. I've
got a hypothetical for you, Senator. Imagine a world in which there is a 6-3 liberal supermajority on the court with even a fraction of the corruption or the ethics violations or the, gift violations. Would your Republican colleagues be saying the same thing that they're currently saying if, basically if the situation was reversed?
No, their hair would be on fire. They'd be screaming from the ramparts. Fox News would have a 24/7 Supreme Court reform crisis tag going. They run a pretty good faux outrage machine to try to scare people away from criticizing them. That faux outrage machine would be like pedal to the metal.
They'd open up a third channel. I think it'd be Fox News Business, and Fox News Supreme Court reform.
Fox News Supreme Court, crisis.
Absolutely. One of the founding principles, if not the founding principle on which this nation was founded, was that we rejected a monarchy. And for them to turn around and say, actually,
maybe not so much.
Yeah.
And particularly, this gets just a slight bit weedy, but there actually is immunity in the U.S. Constitution.
Yes, for you.
It's
for
not
Congress.
For the president. It's for members of Congress because the founders were afraid that executive power would be abused to arrest legislative officials off to go about their duties. So they created legislative immunity. So they knew how to do it. And they didn't do it for the president. They did do it for members of Congress. And even where they did do it for members of Congress, they made exceptions for felonies, bribery, and treason.
Right.
So that's what the Constitution does. Then along comes this gang, and they say, actually, even though the founding fathers didn't mention any of this, we're going to give that to the executive, the chief executive, to the president, And by the way, we're not going to exempt felonies, and we're not going to exempt bribery. We're not even going to exempt treason.
I mean, Justice Sotomayor mentioned that, that these so-called originalists and textualists, man, they bend their principles at the drop of a hat to get a particular outcome.
Principles.
No, it truly is. And what's interesting, too, you also mentioned the clear lack of limiting principle that Justice Roberts articulated in his majority opinion. And reading it, it just made my skin crawl because at multiple points, Senator, as I know you remember, he openly disdained the fears of the liberal justices about coups and SEAL Team 6. But here's what's interesting. He never refuted them. He never said, listen, here's why you need not worry about this immunity that we're giving former presidents. Here's why coups are off the table. Political assassinations are off the table. All he did was disdain them.
Yeah.
And to me, maybe I'm wrong.
Like three hysterical women who just needed to be calmed down by a nice paternal figure like him.
Right, but isn't that also obviously the undertones of sexism aside, but isn't it even also a tacit concession? Like, you had a copy of the minority opinion. You knew what Justice Sotomayor was going to say. There was your opportunity to refute it. Isn't that a concession?
Drop a footnote, put something in there. Nope, none.
Constitutional amendments require a 2/3 supermajority in both chambers. It requires 3/4 of the states to ratify. Our Constitution is the hardest to amend in the world. 12,000 attempts in 250 years, 27 amendments. Senator, last question on this particular reform, and then I want to get your thoughts on the other two, and then a comment recently made by Justice Gorsuch. But how confident are you that this amendment might gain traction, and what can Democrats do to really elevate the call?
Well, I think a lot will depend on how the election goes in November. I think if Trump is elected, he has such a cult following and is so able to whip his Republican elected folks into, lining up for him, that he would make that an attack on him. And then all of his Republicans would line up and salute and kowtow and come into alignment with him. And so you'd end up with this very difficult, challenging partisan wrangle back and forth. If a different president is elected, then all of that nonsense and all that poison goes right out of the system. And then I think people are making an honest decision, a plain decision about, do we actually want to have it be okay for a president to commit criminal acts up to and including treason?
Two other reforms that the president mentioned, Senator, a term limit for justices, which effectively would allow any president to appoint 2 justices during his term or her term to serve for 18 years. Obviously, the current interpretation of the Constitution is that Supreme Court justices serve for life. Would this require an amendment? Would the Supreme Court be able to strike down such a statutory revision to how their court works?
Well, they might, because they want to protect themselves, but I don't think it would be well-founded. And we looked into that constitutional question very carefully. Under our 18-year term limit proposal, they actually do serve for life. And what happens is at the end of their 18-year terms, they go on to effectively senior status, which is a concept very familiar to judges. We have judges on the circuit courts of appeal who've gone on to senior status. We have judges in the district courts who've gone on to senior status. When they go on to senior status, it creates a vacancy, but they stay on the court. Now, in the case of the Supreme Court, the particular business that the term-limited justices who have stayed on the court would do would be to hear the original jurisdiction cases that the Constitution gives to the Supreme Court. So the business of the Supreme Court in the Constitution stays with the original 9 justices in place when the term limit bill passes. And they stay on, and they still have offices and salaries and all of that. The new appointees who fill the vacancy created by their senior status take on the appellate jurisdiction, which is the bulk of the court's work. It's the decisions that come up through the different circuit courts of appeal to the Supreme Court. And that part of the court's work, the Constitution gives to Congress, specifically gives to Congress the power to regulate. So for us to say, this is how we're going to do this with the familiar concept of senior status, the original jurisdiction stuff staying with the original justices, and Congress exerting its power with respect to the appellate jurisdiction, I think it aligns quite well. And it immediately starts to create turnover. And by happy coincidence, it takes the worst behaved justices off the court and onto senior status first. Beautiful. So Roberts, Thomas, and Alito are the first to go.
So the last reform that President Biden mentioned are binding codes of ethics. And my question to you is, obviously this is a no-brainer. I do not believe that even with the full power of the Fox propaganda network at their disposal, that they will ever convince a majority of Americans to not support binding codes of conduct, which apply, as you've made this point in many conversations, to every other government actor in the judiciary, in the executive, in the legislative, except these 9 justices. Would that particular provision be justiciable by the Supreme Court? Could the Supreme Court strike down a Sheldon Whitehouse authored code of conduct, which passes Congress and signed into law by the president?
I would doubt it, because it puts the authority to regulate the Supreme Court's conduct in the judicial branch of government. It's not like we have a panel of senators who are going to sit in judgment of Supreme Court justices. What we require is that the Supreme Court set up its own system. There's nothing unconstitutional about having an inbox where complaints can be filed. There's nothing unconstitutional about hiring somebody to screen out the nutty ones and to have lawyers look through the legit ones. There's nothing unconstitutional about having justices interviewed by Supreme Court staff to say, hey, what went on here, Your Honor? We're going to have to do a little report on this, and we want your statement. You'll have the chance to sign it and review it with your lawyers, but we do need to take the statement. Nothing unconstitutional about that. And there's nothing unconstitutional about a panel of senior distinguished circuit court justices, for instance, like the chief justices, sitting down to say, hey, if this happened in our courts, here's how we do it. This is not consistent with the ethics code as we implement it. And I think that's enough to put a powerful corrective onto the court. Not a piece of it is unconstitutional. And indeed, if you look at the state Supreme Courts, they all have a mechanism very like this. So it'd be hard to say that it's unconstitutional, but all 50 sovereign states do it. And finally, the Supreme Court does this for itself with respect to disclosure stuff. There's a group called the Judicial Conference that is right now investigating Clarence Thomas's disclosures about his Harlan Crow billionaire freebies. So if the theory that this was unconstitutional were real, you'd think they would have raised that when these junior judges, by their estimation, started overseeing and reviewing Clarence Thomas's behavior. And they've been at it, they started on this like more than a decade ago, and Thomas has always accepted this, and the court has never objected. So even they don't have a leg to stand on in their own behavior, set aside comparing it to other Supreme Courts.
Does your legislation and do the president's reforms impose any sort of consequences for, let's say, Justice Thomas or any other hypothetical justice, engaging in the ethics violations with impunity that they have?
That's where it gets, I think, difficult, and where the Supreme Court justices have their best case that lower court judges shouldn't sit in judgment over them, to the extent they're comparing and saying, here's what we find that you did, here are the facts, here are the rules for all the rest of us, and by the way, those facts, your behavior totally does not comport with these rules. So just saying. And then I think they would adjust. To then say, okay, now what are we going to do about it? That gets more challenging. Now, if you look at the existing law, for instance, around disclosure violations, there is a provision that says that if the Judicial Conference finds a disclosure violation to perhaps have been willful, a reasonable likelihood that it may have been willful by the justice, they refer that by law, they're supposed to refer that to the Attorney General who then can do a proper investigation of willfulness. And there is a criminal misdemeanor statute that relates to that. Furthermore, if they've filed false statements, they're not above the law because they're in the Supreme Court. It's a felony to file a false statement with the government. And there's a whole lot of case law and precedent out of DOJ on prosecuting that. And then in a lot of these things, there are tax fraud and tax filing problems. And so you would have the tax fraud and tax violation stuff. And you don't necessarily want the judicial conference to be looking at that because they can't do anything about it. You really need that to go over to the executive branch because now you're dealing with potential criminality. And just the fact that you're a Supreme Court justice doesn't mean you get away with criminality and nobody's allowed to even investigate.
Justice Gorsuch recently sat down for an interview with Fox News, and he was asked by Fox News host Shannon Bream about President Biden's proposed reforms. And Justice Gorsuch began saying, listen, it's a political question. It's an election year. I'm not going to weigh in. And then he proceeded to weigh in, Senator.
But he couldn't resist.
You're right. I mean, it was a full 3 seconds, Senator. He couldn't help himself. But what was interesting was how he ended it. He seemed to be telling the president of the United States to, quote, be careful, end quote, in attempting to reform the court. I'd really like you to weigh in on what. Did you see that clip?
You're not going to be surprised that I'm not going to get into what is now a political issue during a presidential election year. I don't think that would be helpful. I have one thought to add. It is that the independent judiciary means, what does it mean to you as an American? It means that when you're unpopular, you can get a fair hearing under the law and under the Constitution. If you're in the majority, you don't need judges and juries to hear you and protect your rights. You're popular. It's there for the moments when the spotlight's on you, when the government's coming after you. And don't you want a ferociously independent judge and a jury of your peers to make those decisions? Isn't that your right as an American? And so I just say, be careful.
Yeah. Yeah.
What were your thoughts?
You know, there are two possible readings of it. One was a warning, stand back, you know, like a rattlesnake rattling its tail, warning, I'm watching, don't do this. And the second is just, you know, good advice. This is a complicated area of law. And so, you know, people should proceed carefully and not proceed rashly. Even if you give him the benefit of the doubt that it was the latter, that it was just, you know, a helpful observation that this is an area where it's worth proceeding carefully and not rashly. The idea that this court would give that advice, I mean, there has never been a less careful Supreme Court. There has never been a more power-grabbing, policy-lustful Supreme Court. And they don't really care about cleaning up after themselves. They are happy to go and just wreck stuff. Here's my favorite example. In Citizens United, they said that it would be corrupting if the public didn't know who was behind all the big money that was going to be unleashed into politics. The transparency was the defense against political corruption. Well, guess what? We now know it wasn't transparent. There's billions of dollars in dark money that's been spent. It's a complete wreck of their theory that transparency will protect us because there isn't any transparency. They won't go back and clean up. We have corrupted government as a result. And now this is a court that wants to talk about being careful. Really? The Supreme Court has gone from ain't nobody's business but our own to, okay, here's our dumb letter that the 9 of us signed, to, okay, here's a toothless ethics code that we came up with, and we're still pressing. But the direction is going in the right way, and they can't defend being fact-finding free. So we're going to continue to win on that front. The second is, if the House goes Democrat, the Republican senators who told everybody we tried to investigate that they would block any effort to enforce our subpoena by filibustering any effort to enforce our subpoenas. Well, guess what? Republican senators can't filibuster House subpoenas. So a significant major 1-6 commission type House investigation could take place and get to the bottom of all of this. And I think that changes the whole political dynamic once the American public sees all of the awful stuff that has taken place.
That's a note of optimism I definitely appreciate. Like I said, Senator, I appreciate your work. I appreciate your time. Hopefully we'll have another conversation in the future because there's just so much I really want to pick your brain about. But thank you so much for your time.
Great to be with you, Jai. Thank you.